Welcome, everyone. I'm Terri Austin, and you're watching Law&Crime Report. The verdict that you will be hearing occurred last night, even though the same jury found Cayer guilty of brutally killing his ex-girlfriend and her mother. In phase 2 of the trial, they went on to find that Cayer was not guilty by reason of mental disease or mental defect, as they call it in Wisconsin. This means that Cayer will spend the rest of his life in a mental institution. I have with me two amazing guests. We have law and crime legal analyst Julie Rendelman, and we have Dr. Ken Lang. He is a retired homicide detective. I'm going to throw questions both to you, and what we want to know right now is, in terms of the guilty verdict, Dr. Lang, are you surprised?
Terry, no, not at all. Given the circumstances and the evidence that was presented in this case and how it unfolded in the courtroom, at first the prosecution was required to bring forth the evidence to show whether or not Cayer was responsible for this murder, and they were able to do that. But then we delve into the whole psychological aspect of it, and then we start looking at whether or not he was culpable because of his inability or this mental disease that he has. And so as that information unfolded, then that gives the jury a better picture of what we were looking at in the totality of circumstances with regarding to the crime and to the psychological background of this suspect.
Well, let's take a look right now at that jury verdict when it came in. Let's take a look at what they had to say.
State of Wisconsin versus Jacob P. Cayer. We, the jury, as and for a verdict, find as follows. Question number 1. At the time the crimes were committed, did Jacob P. Cayer have a mental disease or defect? Answer, yes. Question number 2, as a result of the mental disease or defect, did Jacob P. Cayer lack substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law? Answer, yes. Dated at Green Bay, Wisconsin, this 13th day of August 2020, signed by the foreperson, 2 dissenting jurors, both with regard to question number 2.
So he was found guilty. Julie, let me ask you this question. We know that this trial was separated into 2 parts. Phase 1 was whether or not he was guilty of actually killing his ex-girlfriend and her mother and brutally stabbing the boyfriend at the time, Joel Kennedy. The jury said, yes, you did do those things. But now in this phase 2, the jury is saying, not guilty by reason, essentially, of insanity. So how does that play out in terms of what will happen to the defendant now? Is he going to jail? Is he going to a mental institution? How long is he going to stay? Tell the viewers what your view is.
Sure. And it's been interesting. I saw a lot of Twitter reactions, and people were very upset about the outcome. And I think a lot of people were concerned that he's going to be freed. And one of the things I've indicated to people is many times when an individual is found not responsible due to an NGI, which is in this case, they end up in a mental institution. In this case, he will be in a mental health institution. And potentially he will be in that institution longer than he could have been if he was simply found guilty. And that's the irony of it all, is that at the end of the day, he will likely not see freedom, whether he was found not responsible or not responsible by reason of insanity.
Exactly. Yeah, I know. I think people don't really quite understand what happens when you're found, quote unquote, not guilty by reason of insanity. You can still go to a mental institution for as long as the prison term might have been, particularly in this case, since they found him guilty of committing these crimes. Let's take a look now at the clip from the judge where she's talking about the actual disposition of the case.
Mr. Cayer?
Hello, Mrs. Hawk.
Hello. We are here today for the, I guess we're calling it disposition hearing. And I have to advise you of a couple of things. I'm also told you want to participate in this hearing by at least participating by phone. Is that correct?
Correct.
All right. I need to tell you that because you've been convicted of a felony, that you're prohibited from possessing a firearm, and because you've been convicted of a violent felony, you're prohibited from possessing body armor. Do you understand that?
Understand.
All right. So the jury returned a verdict now on the NGI portion, the Phase 2 finding Mr. Cayer not responsible. I'm going to make that finding specifically that on all 6 counts, the jury made a finding that Mr. Cayer was not guilty by reason of mental disease or defect, that at least one of the crimes is a felony committed after July 30th, 2002, and the maximum term of imprisonment. Technically, when I look at the case law, there's a case that says that in multiple offense situations, maximum periods of commitment are defined by consecutive max terms. So I believe the maximum is 2 life terms plus, if my math is right, 84.5 years as I do the calculation. And what's the state requesting?
Your Honor, I think clearly that the court should impose a lifetime commitment in this instance. I think it has to with respect to the first 2 counts. I think that's appropriate here. With respect to whatever the court wants to impose on the other charges, I won't take any position as to whether that should be consecutive or concurrent. Obviously, it's the intent of the state that he be committed for the rest
I
of
am
his
going
life.
to order that judgment of not guilty by reason of mental disease or defect be entered for all 6 of the counts that the jury originally made a finding of guilt. And I am going to commit Mr. Cayer to the Department of Health Services for a life term. I will also indicate that I do not believe that I have any issues with having insufficient information to determine whether the commitment should be for institutional care or conditional release. And as a result, there's no need for a predisposition investigation. I therefore find that Jacob Cayer was committed to the Department of Health Services on today's date, August 13, 2020. That on today's date, I determined that conditional release would pose a significant risk of bodily harm to the defendant or others. And I therefore am going to order that Jacob Cayer be placed in institutional care, and I'll sign an order to that effect.
So the judge said life, and that makes sense with this type of crime. The fact that he killed 2 people, almost killed the boyfriend at the time. Let me ask you this question, Dr. Lang. In your experience with this type of crime, do you think that life should have been on the table and the judge should have given him a life sentence?
Terry, absolutely. This was certainly a case where Cayer had premeditated his plan of killing these people. And so the mother comes home, and the actions that he portrayed there in killing or taking her to the bathroom and tying her up and then killing her and then cleaning up and then lying in wait for the second, absolutely. That shows the premeditation, and which couples to that life sentence that we typically look at in a criminal case. But now that he's been found mentally having a mental disease, certainly we're now going to see that life sentence now served out rather than in jail, but in a mental institution where he might be able to get some kind of help with that.
Exactly. You know, Julie, Dr. Lang mentioned something that I was thinking about as far as this defendant Cayer is concerned. Was this premeditated or not? When Cayer was on the stand, the defense attorney tried to make it seem as though it was not premeditated. We actually heard Cayer saying things like, I didn't plan it. And I'm thinking maybe his attorney told him to say that. Did you get that impression?
I didn't, and here's the reason why. I don't think he listens to anybody. I don't think he listens to his attorneys, and I don't think he listens to anyone. I think he beats to his own drum, and so that's the reason I tend to think there was no controlling him in terms of what he was going to say. It's hard when you talk about premeditation because we're confusing premeditation in a sense and mixing it up with the whole idea of mental disease or defect. And so if he acted without being able to recognize the wrongdoing, then premeditated gets a little, I guess, gray when it comes to that, figuring out if he really had that mindset at that time.
That's a good question, Julie. And, you know, I think it doesn't have to be premeditated. He could just understand what he was doing and knowing the difference between right and wrong. And I guess the jury probably decided that he did not know the difference between right and wrong. And so therefore, that's why they found him not guilty. We are going to take a break. And when we come back, we will be breaking down the Jacob Cayer case out in Wisconsin. Welcome back, everyone. We are breaking down the Cayer case out in Wisconsin. The jury found that he was guilty of killing his ex-girlfriend and her mother and brutally injuring the boyfriend, but they found him not guilty because of a mental disease or defect. Let's take a look at what the psychiatrist had to say. Interestingly enough, the prosecution brought on the psychiatrist, but the conclusions were not exactly what the prosecution wanted to hear. They found that the individual did have a mental defect. Let's take a look at what he had to say.
Let's walk through your conclusions. What were your conclusions?
That, first of all, he has either schizophrenia or schizoaffective disorder as his primary diagnoses.
Let me stop you there. Are schizophrenia or you said schizoaffective disorder? Are those mental illnesses?
They are. They're psychotic disorders.
Each one of those is a psychotic disorder.
Correct. They're cousins. The only difference is that with schizoaffective disorder, there's a significant mood component because he has this sort of mania that he has shown the grandiosity, the pressured speech, the tangentiality. That's all typically part of a manic episode, and that's why I considered schizoaffective disorder as well.
Are you the only doctor to diagnose psychotic
3.
disorder or schizophrenia?
No.
How many others have diagnosed that?
Well, Dr. Landis diagnosed that at his recent Mendota admission, where he was started on the risperidone. They ended up diagnosing him with a psychotic disorder, but one of the things they considered was schizophrenia or schizoaffective disorder.
Okay, so it seems very evident that there's a mental illness or a psychotic condition, right?
Correct.
What else did you conclude?
I concluded that I went through the symptoms that I think he was experiencing at the time of his crime. I went through the symptoms that he was demonstrating at the time of previous evaluations to make the case that these symptoms have been reasonably consistent over these 4 years since the crime, and explained why I believe a personality disorder does not clarify what led to his criminal conduct. That while he may have a personality disorder, that's in my view a less important feature than the psychotic disorder. And I made the case that I don't see any evidence of malingering.
Dr. Lang, I think the defense got a bonus here. The fact that that prosecution witness ended up saying, yes, the defendant was mentally ill. What was your thought about the defense being able to call this Dr. Robbins on for their case?
So I think that it's an attribute that is afforded to the defense to do this and to bring it on. And I really think that it does bring a fair and unbiased light to the defendant with regards to the mental illness. But often the general public as a whole, they don't often understand this, particularly given the history that we had with infamous killers who have been tried, convicted, and even executed. And then this psychological background really doesn't come into play or has not been afforded in their particular case. And so that can give mixed signals to the public about whether or not it's just or not. But in this case, certainly, it was a just pursuit for the defense to bring that forward.
Right. Julie, let me ask you this question. We did not see any other evidence other than from this doctor. So there was no disputing essentially what was going on as far as the mental capacity of Cayer. Do you think that hurt the prosecution? Do you think they should have been shopping for, at least I didn't see another physician, and I watched, I think, the entire trial. Do you think that had they had evidence that he was saying that, in fact, he had no mental disease, no mental defects, no mental issues, do you think that would have helped?
Absolutely. It's interesting. Here's a case where you had a doctor that, remember, this is before the trial happens. This doctor is hired by the prosecution to evaluate this defendant. And this is a doctor that gives his opinion, whether you're a prosecutor or whether you're a defense attorney. Some doctors, we all know this, that work in this field will only work for the prosecution and sometimes will only work for the defense. So you have a doctor who's pretty neutral in terms of his decision making. And the fact that the prosecutor hired him, and then he came with a decision that was contrary to the prosecutor's position is not unusual. But usually the prosecutor relies on that to allow the defendant to plead to a NGI. We've done it plenty of times when our doctors who we trust make that conclusion, then we rely on that and we don't go to trial and we allow him to plead. Now, it's possible that he refused to plead. Remember, there were some issues with Cayer, whether or not he was even willing to go to a mental hospital. There were some discussions about that. So that may have been the reason that they proceeded the way they did.
That's an excellent point, Julie. I was thinking the same thing myself, like, why are they proceeding if the prosecution's own physician said that there was a mental illness? Let's take a look at what Dr. Robbins had to say further in the trial.
There were a number of times within the course of that recording where Mr. Cayer is actually expressing remorse for his conduct. Wouldn't you agree?
He is all over the place, but included in his all over the place was some remorse for his conduct, yes.
He said, I fucked up. Correct? He said, I really hope someone isn't dead. Correct?
Correct.
He was concerned that his mother was going to see him on the news. Correct?
Correct.
He specifically said to Officer Holschbach, I did something totally against my belief. It's not fair what I did. Did you observe that?
Did.
Isn't it fair to think that all of those statements are inconsistent with someone who could not appreciate the wrongfulness of his conduct?
No, I think, so it's not clear what he's saying he did. It's not clear when he says, I fucked up. It's not clear what he's referring to exactly, because he is just so all over the place about what he thinks he may have done, from getting into an automobile accident to bits and pieces that are somewhat incomprehensible. So it's confusing, honestly, to read through that and to try to understand what exactly he's referring to when he's speaking.
But Doctor, wouldn't you agree that this is why it's really important to have listened to all those audio tapes all the way through? Because at the outset, Mr. Cayer is clearly expressing that confusion. He comes into the hospital and he's saying, whose car did I steal? What did I do? But slowly over the course of that night, he knows exactly what happened as he's walked these officers through specific details. And if he's making these remorseful statements at the end of the night, after he's made it quite clear what happened, that information is inconsistent with someone who doesn't understand what they've done. Correct?
So I think there were moments in time where it did appear that he knew what he'd done. I agree.
But don't you think under these circumstances, it would have been a lot more valuable to be able to hear that full recording and really have a full and complete understanding of how Mr. Cayer's night unfolded in terms of that confession or statement to law enforcement?
I felt like I got a pretty good sense of it.
First thing I have to say is there were a lot of F-bombs in this particular trial. First of all, obviously, Cayer was saying it, but then when you have to repeat back what he said when he was captured or when he was interviewed, then, of course, you are going to hear it. You will not hear it from me. Dr. Lang, let me ask you a question. When he was first captured in the brush behind the house, he did make it seem to the police and the authorities that he did this. He said, the knife is in the house and I'm here, but I don't have any weapons. And he started talking about a little bit what happened in that instance. Do you think that in his time frame at that point, he had a mental illness, or did he know what was going on? What's your thought about when they first captured him?
So Terry, when they first captured him, these types of cases are highly emotional, and it's not unusual to arrive on the scene and have those people who were involved or witnessed or even survived the attack to have a whole myriad of emotions that they'll display. And so it's not uncharacteristic for officers to see this initially, and it really makes it difficult for us to make an initial assessment unless the person is saying something really off the wall that causes us to for that red flag to go up or causes us to pause. And in this situation here, what he's saying here much to the officers is much in like, what he was saying to officers later at the hospital, where he's concerned about himself, really, if you listen to his statements. And so he was afraid he was going to be on TV. He says he hoped nobody was dead. But as I was listening to what the doctor was reiterating as far as his statements, they seemed to center more on his concern about himself rather than the victims in this crime.
Right. I think you're right. He does come in and out. Sometimes it seems as though he knows what he's talking about. Other times it seems as he is a little bit delusional. Let's take a break. And when we come back, we will be analyzing the Cayer case out in Wisconsin. Welcome back, everyone. We are breaking down the Jacob Cayer case out in Wisconsin. The jury came back after 10:30 last night and found him not guilty by reason of mental illness or defect. Let's take a look at what his attorney said during closing arguments.
Jacob Cayer has a profound mental illness. The breadth and depth of the evidence in this case suggests that he is very profoundly mentally ill and a very sick person. I want to talk to you about the evidence you heard today because we're at the second phase of the proceedings, and fortunately it was just one day, and so all of you have had an opportunity to hear really one witness. There was a few audio clips or a few video clips that were played, but you did hear from Dr. Robbins, and I want to talk and summarize just a little bit of what you heard today. It's all fresh in all of your memories, so I hope not to belabor the point too much. As the judge indicated, we have the burden of proof at this stage of the proceedings, which I certainly welcome and accept that. The burden of proof that we have is not nearly as high as the state's burden of proof when they had to prove guilt beyond a reasonable doubt. It's a lower burden, which the judge had read to you, which means that you have to have reasonable certainty, meaning that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required. I don't think anybody can have absolute certainty in a whole lot of things. That's certainly not required. With your finding that he lacks, with your finding in support of NGI, Mr. Cayer, as the judge told you, will be committed to that maximum security mental health hospital that Dr. Robbins discussed. It's very much like a prison. The only difference, of course, is so from a security perspective, it's very much like a prison. But of course, the positive feature is that Mr. Cayer will be increasingly medicated as the years go by to hopefully get to a point where the mental health issues are brought under control and the level of violence is reduced accordingly. I think it's very tough for Mr. Cayer's family and Mr. Cayer himself to deal with this, and it's obviously very tough for the Teague family and Mr. Kennedy, the horrors that they have to go through. Everybody here has really gone through horrors, I would say. But we can't let emotion of the horrors control the decision that you've sworn to make. And the decision you have been sworn to make is to listen to the evidence and find Mr. Cayer, find that NGI is supported when the evidence supports that.
Julie, we just heard Cotton, the defense attorney. Actually, it was a little difficult hearing him. He's having trouble with the mask there. That's something I think we're going to have to deal with now with COVID-19. But we heard him say that his burden was a little less for NGI. I think it's 5/6 of the jurors out in Wisconsin, lesser standard than beyond a reasonable doubt. What were your thoughts about making sure the defense convinced at least that number of jurors that the defendant had some mental illness or defect?
So, obviously, I think it's imperative for him to, again, talk about the judge's instructions regarding the fact that this is not beyond a reasonable doubt, which was the burden that the prosecutor had. Instead, it's, I believe they call it reasonable certainty, which no one can be certain. And the other thing that he has going for him that many other jurisdictions don't is he's allowed to tell the jury that if you find him not responsible based on mental disease or defect, he's not going home. He's going to a maximum mental health secured facility. That's not something we usually are able to tell the jurors in New York. The jurors don't know. And so a lot of times the jurors will go along with guilt and be very nervous about an NGI because they think the guy's going to get released. And so that's the big thing I think that in his situation he has going for him is that the jurors feel comfortable that they don't have to consider that aspect when they're deciding if in fact he has that mental disease or defect.
That is such an excellent point. I definitely think jurors think about those issues. The fact that if they say he is not guilty by reason of mental disease or defect, what will happen to the defendant if they find him not guilty because of that? And I think to your point, the fact that they know what's going to happen really does give them some ease. Do you think that we should have had any more medical evidence? That's something I keep coming back to. Clearly, the defense did a great job, and they argued there in their closing about the mental state of the defendant. But would you have put more evidence in as far as his mental state was concerned?
No, and I think that we talked about this the other day with Bob Bianchi. I think that the defense did a pretty fantastic job, not just at this phase, but at the earlier phase. I think they were incredibly smart to put him on the stand, the defendant on the stand, because I think they very well knew the minute he got on the stand, he would not be able to be controlled. And the way he acts on the stand, to me, is very indicative of some of the things that they're looking for when it comes to mental disease or defect. When it comes to this doctor, I think the fact that this doctor did so well, not just on direct, but fantastic on cross. B, the fact that he was the prosecutor's own doctor, and C, the fact that this doctor not only testified about what his opinions were, but he was able to get out the opinions of every single doctor whose reports he reviewed. And so at the end of the day, it came in as, a lot of hearsay, and the jury was not really in a way considering just this doctor, but considering every single doctor that report he reviewed that supported him. So I think at the end of the day, I think it was perfect.
Excellent points, as always, Julie Rendelman. All right, let's take a look at more of that closing argument that Cotton had to make in the closing of this case.
I want to talk a little bit about what I think the state's theory is. I think the theory here is that Mr. Cayer is faking mental illness, or that he is putting on a show somehow. And I think the evidence is so abundantly contradicts that concept that I almost would rather hear it before I address it. But I want to talk just a little bit about it. Every single evaluation that's happened of Mr. Cayer, he has persistently rejected the notion that he is mentally ill. Every single time, including probably in court when he testified the other day, but certainly when he met with Dr. Robbins, who was hired to do an NGI evaluation. Every single person who's interacted with him in a professional capacity, Jacob Cayer has insisted, I'm not mentally ill. I am not mentally ill. And then he weaves in a theory about some interconnection between three women and nonsense theories about being ganked and all this other stuff that he is delusional about. They're all delusions, apparently. But he is persistent. He's not mentally ill. This is the exact opposite of a person who is trying to convince you to commit him because he has a mental illness. He's fought that every step of the way throughout his life. Even one of the tapes you saw one of the tapes in this case, he's even arguing with medical professionals when they bring up psychiatric conditions. So I don't think the evidence supports the notion that Jacob planned out this crime, planned to commit this offense, was done in such a haphazard, inexplicable way, with a long knife still in his backpack and no attempt to conceal anything and no real attempt to hide himself or wear gloves or anything. It's just a very sort of senseless, inexplicable thing. And his son it just doesn't make any real sense whatsoever. There's no real attempt to flee. But it doesn't appear to be founded in reality that Mr. Cayer is faking any of this mental illness. I think he truly, in his mind, because he's not medicated, he believes that he doesn't have anything wrong. Even when he went to Mendota, when he was committed, what did he do there? Refused to take medication, told the doctors he's not mentally ill, despite medical professional after medical professional explaining that he is. And it wasn't until the doctors actually put someone there to physically monitor him to make sure he takes the liquid medication, it wasn't until then that he even actually would take it.
Those were very interesting arguments. One of the things that the defense attorney is saying there is that his client wanted to take the stand. His client thought that he was perfectly sane, did not have any mental issues. How does that affect the case, Julie, when you have a client who is basically trying to say earlier that I was competent, and now during this part of the trial saying that he doesn't have any mental issues and he knew what he was doing essentially?
So this kind of goes back to what we were talking about before, is we were saying, well, why did they go to trial if the prosecutor's own doctor said that he was, basically NGI? And this may be the answer, which is that the defendant may have refused to go along with that plea. Now, with that said, and I'm not sure how it works in Wisconsin, because they did go for an NGI, there could, I guess, be some aspect or argument for appeal if the defendant's position is, I didn't want us to go that way. I didn't agree to go that way. Time will tell with that. At the end of the day, whether he's in a mental hospital or he's in jail, he's not getting out anytime soon.
Julie, you're our expert here, and I would love for the viewers to understand, because I don't think everyone does, the difference between the competency and whether or not there is a mental illness or defect. We know the trial was delayed many times because of the competency issue. Can you explain the difference there?
And it is, by the way, it's even hard for lawyers to understand the difference. And so, keep in mind, when we talk about competency, we're talking about competency right now, not then, not during the crime, not 5 years ago, but is he competent right now to stand trial? And what does that mean? Well, does he fully understand what's going on in the courtroom? Does he understand what the judge is saying? Is he able to assist his attorney in his defense? Those are kind of the things you think of when we think about competency. When we talk about NGI, it's a completely different issue. We raise it a lot of times in a defense because if someone's not competent, there may be issues regarding that mental disease or defect. But when it comes to mental disease or defect, it's only during the moment that the crime happened. In this specific case, it's I believe it's whether or not he understood the wrongfulness of what he had done at the moment that the crime happened. And so it's a separate standard and it's a separate set of circumstances. And so you're looking at different things. And so when sometimes people intertwine the two and they're not quite right, even though they're hard to distinguish sometimes.
And Julie, this is why we pay you the big bucks to explain things like the difference between competency.
I was going to make a joke, but I will not make a joke.
And mental defect. And I do think they applied the McNaughton rules. So you're absolutely right on that. The fact that did he know right from wrong? Let's take a quick break. And when we come back, we will analyze this case out in Wisconsin when we get back. Welcome back, everyone. We have been following the Jacob Cayer case out in Wisconsin. The jury came back with a not guilty because of mental defect. We heard a little bit of the closing argument from defense counsel. Now let's take a look at what the prosecution closing had to say.
Defendant's lack of understanding as to the state's position is frankly consistent with Dr. Robbins' lack of understanding of the facts of this case and his lack of understanding of what he needs to do to actually demonstrate the burden of proof that's before you here today. The state is not arguing, and nobody is arguing, that Mr. Cayer is totally fine, that there's nothing wrong with him, that he doesn't have any mental problems. No one's making that argument. How could we? How could anyone make that argument with a straight face? You saw him, you observed him. That's not the legal standard. If the legal standard was get a doctor, have the doctor make an evaluation, and have the court make the decision based on the doctor's evaluation, we wouldn't have a jury hear part 2 of this case. It's not the doctor's opinion that matters, it's your opinion that matters. You were instructed, and you'll be instructed again. You'll have those instructions back with you, that you give that doctor's opinion the weight that you give the opinion of anyone else. Is he credentialed? Is he an expert? Does he have good character? Yeah, absolutely. And the state did retain him, presumably because he's good at his job. There's no question about that. But his role is not to decide Mr. Cayer's fate. His role is to offer you an opinion for you to consider in light of all of the other facts and circumstances of this case. Don't let Mr. Cotton convince you that you only heard from one witness today and that's all that matters. There's a reason why this is a 2-phase trial with the same jury, because you heard all of the other evidence in this case. And all of that other evidence in this case can and must be considered in this phase as well. You know what you heard, you know what you perceived, and frankly, you know a heck of a lot more about this case than Dr. Robbins does. It is completely disingenuous to suggest that he reviewed literally everything in this case. On cross-examination, it was abundantly clear that he had not reviewed some of the most essential pieces of information in this case. He didn't see how Mr. Cayer reacted just minutes after this crime when he's taken into custody by law enforcement. He didn't actually see and perceive and witness Mr. Cayer throughout the course of his interview with law enforcement hours later. He basically watched the clips from right when he arrived at the hospital. And there's no doubt those clips are disturbing. They are. They clearly show somebody who is in distress or is pretending to be in distress or is exacerbating his distress at that particular moment. They don't show you what Mr. Cayer was doing 2 hours earlier. When Joel Kennedy describes him as calm, cool, collected, not saying anything, hiding in the closet, having planned out these murders.
Ken Lang, let me ask you something, Doctor. You're listening here to the prosecution actually ripping apart the testimony of the doctor that he hired. What would you be thinking if you are a juror on this case at that moment in time, as far as what the doctor testified to?
So as I'm listening to this, I become perplexed myself in that here is an instance where the prosecution is, as you say, ripping apart the psychiatrist who was appointed to evaluate. But throughout the whole trial, you brought forward, as you would in any trial, experts with expert testimony who testified, and I'm supposed to believe this information, but then now I am supposed to ignore the information from the analysis of the psychiatrist in this case and draw my own judgment and conclusions where I have no background. And so those were the thoughts that that were coming across my mind, in that I didn't quite understand why the prosecutor went in this direction to rip apart the psychiatrist and have the jurors ignore what he said, when we live in a day and age that forensics and evidence has become so advanced that this scientific approach is really an important aspect in many of our trial situations.
Yes, exactly. Before we go to break, let me ask you another question, Dr. Lang. Do you think the jury paid more attention to what the psychiatrist had to say, or to how they viewed the defendant himself on the stand?
I really think that it was a combination of both in tandem, in that they've had the opportunity to witness the Cayer's actions on the stand and then couple them with the assessment of the doctor. And then in their way, they've already drawn their own conclusions prior to the prosecutor asking for them to do so.
Okay, right. Listen, let's take a look at another clip of the closing arguments in this case.
I want to return to those videos that you saw getting off the ambulance because they are disturbing. They're disturbing videos. But none of the other interactions that any of the professionals or this court system, this court right here, you saw him testify. None of those are consistent with what you saw in those videos. Those videos, he's non-functioning, he's rolling around, he's thrashing, until he sees the cameras rolling, and he goes, "Oh, you filming? You filming me? You recording me?" He asked 5 different times, "You recording me?" He wants to be recorded. He wants you to see that. And there's no doubt that he had been through substantial trauma at that point when he gets out of that ambulance, right? He just murdered 2 people, tried to kill another, hid in the woods, chased down by a dog, bit, brought to the hospital, and he knows what he did. He knows what he did. There's emotional stress and trauma that goes with that to exacerbate what he might have for mental illness before that. And again, I don't contest that he has a mental illness. There's no question about that. But none of the interactions that we see from these other doctors and the interactions we saw on the stand are consistent with that level of just not understanding what's going on around you or being disoriented. He's confused, but his thought process is quite different. You saw his thought process. You saw how he testifies and appears in court. And that's the same thing that Dr. Robbins describes. He comes across as grandiose, as arrogant, right? And he's a business owner. His business is, of course, repoing stolen items, apparently. But he comes across as knowing more. He needs to help Mr. Johnson tie his shoes, right? But that level, that mental illness that you saw displayed is not consistent with what you saw in that hospital. That's completely different. So to the extent that we think he's playing up his mental illness, maybe in those videos, right? I don't deny that he has a mental illness, though, and I don't think this is a falsified claim of mental illness overall. But certainly there's a suggestion that he may have been playing up what's happening at that hospital a little bit.
So the prosecution is not denying that Jacob Cayer had a mental illness. He's just saying that at the time the crime was committed, Cayer knew what he was doing. Julie, you agree with that? And you think that that's persuasive enough? Obviously, we are seeing that the jury already made up their own mind. But what are your thoughts about that?
Look, I think the prosecutor had a lot of areas they could have hit. And just to go back in regards to the doctor, one of the things they did bring out that I think was good for them was that the doctor did not review all of the videotapes. And if it was my expert, I would be really upset if they haven't reviewed every single piece of evidence. Not because I think he's going to find something new, but because you never want him up on the stand saying, "Oh, wait, I didn't review that, but I reviewed some of it." And so that was one area that the prosecutor was able to nail him on. And that gives the jury a reason why the prosecutors wouldn't have stayed with him as their expert, because they didn't feel like he had reviewed everything. I do think there's a fairly good argument, although obviously it was a losing one, that there was more to what Cayer's mindset was when it happened, and that there were certain acts he took that even if he wasn't mentally sound, that he understood that he was committing a crime and that he could get caught and in trouble for that crime. And I think the perfect example is him hiding outside in the back. That's an indication of someone that knows they've done something wrong and is hiding to make sure they're not caught.
Exactly. You raised some excellent points there. Dr. Lang, do you agree the fact that he did know what he was doing when he committed this crime? He was trying to cover up and hide out. So at the time the crime was committed, he really had, he knew right from wrong. Do you agree with that?
Yes, I do, Terry. But the question becomes is where do we draw the line for that threshold, and where somebody becomes has a mental disease or NGI, and so and as pointed out, the facts in this case, he did do certain things that would lead a reasonable person to believe that he was guilty and culpable, and in a good state of mind to understand that what actions he had just completed were wrong in and of themselves. But then we have the doctor's analysis, and then that comes in, and then that starts to begin to move where that threshold goes.
I agree with you, and the jury came to the right decision. I want to thank you, Julie. Thank you, Dr. Lang. Have a great weekend, everybody, and follow our schedule.